Cases come to us in all forms, but usually the main thing that sends it to the Issues and Appeals Group is a legal issue arises.
Sometimes the way I describe it is we're the goalie. Another side is trying to score the goal to get the case knocked out. We're there as the goalie to help keep it, we save it. But also, as any good defense knows, a great defense is a good offense. So we try to think proactively ahead of time.
When you bring a lawsuit, the trial lawyers do the offense. They're trying to get the proof together to push the ball across the goal line. But there's somebody fighting back. There's somebody on the other side trying to get our case dismissed. And the Issues and Appeals team plays defense. We keep that from happening. We file the responses. We keep the case alive when it's challenged.
We're not on the defense when it's, kind of at the 1 yard line and they're about to score. We want to get on ahead of time when they've just gotten the ball. And if it's something that is kind of new or unique to the firm or we haven't done as much, we're brought in earlier before the other side even files a motion.
And we work a lot on what we write. We talk about it, we go back and forth, we spend time organizing it. Because when you're talking about a point of law, it's the brief in the judge's hands with arguments written out that they can read over time and again and think about and compare to what the other side wrote out. That's how they decide the case, by what they've got in their hands, the authority and the written briefs that they can mull over to make the tough decisions on sometimes obscure legal issues.
It's a great opportunity for teamwork because I'll do a first draft and I'll send it to Kevin, and Kevin will then revise it and he'll do red lines so I can see what he says. And then I'll take it and I'll revise it, and then Kevin will revise it. And so there's this back and forth. And then sometimes it's not just the two of us. There's 5, 6, 7 people looking at it and integrating everybody's thoughts and thinking through and debating them. Well, I'm not sure I like that change. Here's why I don't like that change. Or would you consider this change to your change? There's this constant refinement and improving so that when it gets to the final written product, you want every word to be just the right word.
You want it to be interesting. People hear about writing legal briefs and they think it's terribly boring, or reading legal briefs is terribly boring. So we really aim, when we write a brief, to use the right language, to make it interesting, short sentences, have the right structure so that the reader knows what you're going to tell them, and then we're going to lay it out in points. And so the reader can follow along as they're going through our brief and know right where we are, because we don't want to make it more complicated than it has to be. It's a legal brief, so sometimes it's complicated, but we want to lay it out as simply as we can because we want the court not to have to work to follow what we're saying.